Welcome to TaxPundit. Today we discuss a landmark judgment in the case of Dilip Patel versus the Principal Commissioner of Income Tax, Central. The Gujarat High Court, in the case of Dilip Patel versus the Principal Commissioner of Income Tax, Central, Ahmedabad, delivered a landmark judgment on the 1st of May 2026, quashing revision notices issued under Section 263 of the Income Tax Act, 1961. The decision underscores the fundamental principle that the power of revision under Section 263 cannot be exercised to substitute a plausible view taken by the assessing officer, AO, with another view, merely because the commissioner holds a different opinion. The court meticulously analyzed the twin conditions precedent for invoking Section 263. The assessment order must be both erroneous and prejudicial to the interests of the revenue. This commentary delves into the facts, legal reasoning, and implications of this judgment, which serves as a critical precedent for taxpayers and tax authorities alike. The petitioner, Dilip Patel, filed his return of income for assessment year 2019-20 on the 3rd of October 2019, declaring a total income of 2 crore rupees 36,22,720. A search and seizure action under Section 132 of the Act was conducted on the 15th of October 2019 in the case of the Land Broker and Financier Group. During the search, a Memorandum of Understanding (MOU) was seized from the mobile phone of one Mr. Dhaval Teli. They indicated a proposed sale of land at survey number 329 for 39.32 crore rupees between the petitioner, as proposed seller, and a proposed purchaser. However, the transaction did not materialize due to title disputes. The actual sale of the same land was eventually executed on the 12th of April 2018 for 12 crore rupees to different buyers. Based on the incriminating material, proceedings under Section 153C of the Act were initiated against the petitioner. During the assessment, the AO referred the matter to the Departmental Valuation Officer, DVO, who determined the market value of the land at 28.50 crore rupees. The AO passed the assessment order under Section 153C on the 19th of June 2023, adopting the DVO's valuation and making an addition of 16.50 crore rupees, 28.50 crore rupees minus 12 crore rupees. The petitioner appealed this order, and the appeal was pending. Subsequently, the Principal Commissioner of Income Tax, PCIT, issued a notice under Section 263 on the 28th of February 2026, seeking to revise the assessment order on three grounds. The AO ignored the incriminating showing 39.32 crore rupees and instead relied on the DVO report. B. The AO took a divergent view compared to the case of the purchaser, where notices under Section 153C were issued based on the amount. And C. The AO failed to record satisfaction for initiating penalty proceedings under Section 271D of the Act. The petitioner challenged the Section 263 notice before the High Court under Article 226 of the Constitution. The Gujarat High Court, comprising Honorable Mr. Justice A.S. Supahiya and Honorable Mr. Justice Pranav Trivedi, allowed the petitions and quashed the revision notices. The court's reasoning is structured around the core legal principles governing Section 263. 1. The twin conditions of Section 263, erroneous and prejudicial. The court reiterated that for the PCIT to assume jurisdiction under Section 263, the assessment order must satisfy two cumulative conditions. It must be erroneous and prejudicial to the interests of the revenue. An order is erroneous if it is based on incorrect assumptions of fact or law, or if the AO failed to make necessary inquiries. Prejudice to revenue means the order has resulted in loss of tax revenue. The court found that neither condition was satisfied in the present case. 2. The AO conducted thorough inquiries and took a plausible view. The court emphasized that the AO had conducted a thorough inquiry into the transaction. The AO considered the incriminating the DVO's valuation report and the registered sale deed. The AO made a plausible addition of 16.50 crore rupees based on the DVO's report. The court held that the mere fact that the PCIT disagreed with the AO's decision to rely on the DVO report instead of the amount does not make the order erroneous. The AO's view was a plausible one, supported by evidence. The court cited the principle that revisional powers cannot be used to substitute a plausible view with another, even if the commissioner considers the other view to be better. 3. The commissioner cannot substitute his opinion without finding error. The court noted that the PCIT's notice did not allege any failure on the part of the AO to conduct an inquiry. Instead, the PCIT sought to substitute his own opinion regarding the valuation of the land. The court held that this is impermissible under Section 263. The power of revision is not a power of review or appeal. It is a supervisory power to correct orders that are legally erroneous. Since the AO had taken a plausible view after considering all relevant material, the order could not be termed erroneous. 4. The issue of divergent views in the purchaser's case. The PCIT argued that the AO took a divergent view because, in the case of the purchaser, notices under Section 153C were issued based on the amount of 39.32 crore rupees. The court rejected this argument on two grounds. First, the satisfaction note in both cases was recorded for the full amount of 39.32 crore rupees. It was only during the assessment that the AO called for the DVO report. Second, and more importantly, the assessment in the purchaser's case was never completed. The purchaser had challenged the Section 153C notices before the High Court, and the court had quashed those proceedings on the 24th of November 2025, holding them to be bad and illegal. Therefore, there was no final assessment order in the purchaser's case to compare with the petitioner's case. The PCIT's reliance on a non-existent assessment was baseless. 5. The penalty proceedings under Section 271D. The PCIT also faulted the AO for not recording satisfaction for initiating penalty proceedings under Section 271D for alleged violation of Section 269 SS, relating to mode of taking or accepting certain loans, deposits, or specified sums. The court held that this ground was unsustainable because the AO had no jurisdiction to initiate such proceedings at the time of passing the assessment order. The court noted that the provisions of Section 271D require the AO to be satisfied that the assessee has violated Section 269 SS. However, the AO had already considered the transaction and made an addition based on the DVO report. The failure to initiate penalty proceedings does not, by itself, render the assessment order erroneous, especially when the AO lacked jurisdiction to do so at that stage. 6. The principle of plausible view and non-interference. The court heavily relied on the principle that if the AO has taken a plausible view after making due inquiries, the Commissioner cannot invoke Section 263 merely because he disagrees with that view. The court cited the decisions in Aryan Arcade Limited versus CIT, Gujarat, JMC Projects, India, Limited versus PCIT, Gujarat, and Abhijit Bhandari versus PCIT, Madras, to support this proposition. The court held that the PCIT's attempt to revise the order was an exercise in substituting his opinion, which is not permissible under the law. The Gujarat High Court's judgment in Dilip Patel is a significant victory for taxpayers and a clear message to tax authorities. The court firmly held that the power under Section 263 cannot be used to reopen a completed assessment merely because the Commissioner holds a different view on the valuation of assets or the interpretation of evidence. The AO had conducted a thorough inquiry, considered the incriminating material, and made a plausible addition. The PCIT's notice was based on a misunderstanding of the facts and the law. By quashing the revision notices, the court reinforced the principle that the revisional authority must respect the AO's discretion when the AO has acted reasonably and after due inquiry. This judgment will serve as a crucial precedent in cases where the revenue seeks to revise assessment orders based on subjective disagreements rather than objective errors. What is the main legal principle established in the Dilip Patel case? The main principle is that the power of revision under Section 263 of the Income Tax Act cannot be used to substitute the assessing office's plausible view with the Commissioner's own opinion. The Commissioner must find that the assessment order is both erroneous and prejudicial to revenue, and mere disagreement with the AO's decision does not satisfy this condition. Access full analysis and official PDF right pointing arrow. Thanks for watching the video. Please subscribe for more such updates and visit taxpundit.org to download the case law PDF file and full case digest.